Tonight, we begin with a story that strikes at the heart of American freedom. The United States Supreme Court has delivered a rare, unanimous 9-0 ruling. This decision draws a clear line. Government cannot use its power to silence voices it dislikes. The case, National Rifle Association of America versus VULO, asks if officials can pressure private companies to cut ties with groups based on political views. The court's answer? Absolutely not. This ruling arrives amid heated debates over government threats to media companies and free speech. All 9 justices, across the ideological spectrum, agreed there are boundaries government cannot cross. The right to express even unpopular opinions is protected from government coercion. Now, this principle faces a new test in the world of broadcast media. To truly grasp the significance of this Supreme Court decision, we need to look back at the events that set it in motion. This case is not just about a single dispute, it's about the boundaries of government authority and the protection of fundamental rights in America. We must revisit its origins, tracing the story to a time when tensions between advocacy groups and government officials were reaching a boiling point. The controversy began when the NRA accused New York regulator Maria Vullo of crossing a line. According to the NRA, Vullo didn't pass new laws or regulations. Instead, they claimed she used her position to quietly pressure banks and insurance companies, urging them to distance themselves from the NRA, not through official channels, but through what they described as intimidation and backroom threats. The NRA argued that this was more than just a policy disagreement. They said it was a direct attack on their First Amendment rights, the right to speak freely and the right to associate with others who share their beliefs. For the NRA, this was about defending the core freedoms that define American democracy. The case raised a fundamental and troubling question. Can a government official, simply because they disagree with a group's message, use their influence to threaten or coerce that group's business partners? If so, what does that mean for the future of advocacy and dissent in the United States? The NRA claimed that Vullo's actions didn't just hurt their reputation, they created a climate of fear throughout the financial industry. Banks and insurers, worried about government retaliation, began to cut ties with the NRA, making it nearly impossible for the organization to access basic financial services. This, they argued, was a chilling effect on free speech. Recognizing the national stakes, the Supreme Court agreed to hear the case. The justices understood that their decision could set a precedent affecting not just the NRA, but any group that finds itself at odds with powerful officials. At its heart, this case wasn't about gun rights or the Second Amendment. Instead, it was about the First Amendment, about defining the limits of government power in a world where the words and actions of officials can have far-reaching consequences for free expression and association. The stage was set for a landmark ruling, one that would determine how far government officials can go before their actions cross the line into unconstitutional overreach, and what protections Americans truly have when it comes to free speech. The heart of NRA versus Vullo: can government punish views it dislikes by pressuring private businesses? After the Parkland shooting, Vullo urged banks and insurers to reconsider ties with gun groups, allegedly offering leniency on other matters if they complied. The NRA argued this was more than persuasion, it was a threat, using regulatory power to silence them. The legal debate centered on the difference between government speech and unconstitutional coercion. If government can pressure a bank to drop a client today, what stops it from targeting any group tomorrow? The Supreme Court had to consider the chilling effect. Businesses might avoid serving controversial clients out of fear, silencing voices without passing a single law. The stakes were clear. This was about protecting everyone's right to be heard. In June 2024, the Supreme Court delivered a unanimous verdict: the NRA's lawsuit could proceed. Justice Sotomayor wrote, "Government officials cannot attempt to coerce private parties to punish or suppress views the government disfavors." The court didn't rule on gun policy, but on government conduct. The message: government cannot use private companies as proxies for censorship. The decision sent the case back to lower courts, affirming the NRA's plausible claim of unconstitutional coercion. The ruling was celebrated by free speech advocates across the spectrum. Groups from the ACLU to conservative foundations supported the core First Amendment principle at stake. The decision reinforced that government shouldn't decide what speech is acceptable. The free marketplace of ideas must be protected from both direct and indirect government interference. The Supreme Court's ruling in NRA versus Vulo is already reshaping American law and business. Government officials are now on notice. Using regulatory power to punish speech is unconstitutional. This precedent shields individuals and groups from being unfairly targeted for their views. Companies now have legal backing to resist government threats tied to controversial clients. The ruling helps depoliticize business decisions, fostering a more stable environment. For Americans, it protects the diversity of voices in public discourse. Unpopular or controversial viewpoints can't be silenced through backdoor government pressure. The decision checks executive overreach, reminding officials their power has limits. Regulatory authority cannot become a tool for censorship. This principle is now being tested in the high-stakes world of broadcast television. The principles established in the Vulo ruling were not just theoretical, they were about to face a real-world challenge, one that would test the boundaries of government authority and the independence of the press in America. In September 2025, a political firestorm erupted when President Trump and FCC Chairman Brendan Carr publicly questioned the legitimacy of ABC's broadcast license. Their criticism came after a series of pointed satirical segments aired on Jimmy Kimmel Live, which had taken aim at the administration's policies and leadership. Carr's remarks, delivered in a press conference and echoed across social media, suggested that broadcasters should be extremely cautious about the content they air, especially when it comes to criticism of those in power. To many, his words sounded less like a warning and more like a direct threat, raising alarms about the potential abuse of regulatory authority. The reaction was swift and dramatic. Nexstar and Sinclair, two of the nation's largest station owners, immediately dropped Jimmy Kimmel Live from their lineups. Within days, ABC announced the suspension of the show, citing regulatory uncertainty and the need to protect their affiliates. The timing was especially notable. Nexstar, at that very moment, had a high-stakes merger pending before the FCC. This raised serious concerns that the company's decision to drop the show was less about content and more about avoiding regulatory retaliation, a textbook example of coercion in action. Legal experts and media watchdogs quickly weighed in, calling this episode a real-world test of the Supreme Court's Vulo decision. The question was clear: would the court's protections for free speech hold up when powerful regulators flex their muscles? Critics argued that Carr was doing precisely what the Vulo ruling had forbidden, using the threat of regulatory power to silence a disfavored voice in the media, and sending a chilling message to other broadcasters. The rapid, almost panicked response by companies with business before the FCC was seen as undeniable evidence of the chilling effect such threats can have on free expression and journalistic independence. As tensions mounted, it became clear that a major legal and political showdown was now inevitable, one that would determine the future balance between government oversight and the freedom of the press in America. Legal experts across the spectrum quickly weighed in on the FCC controversy. The consensus: the FCC chairman's actions, under the Vulo precedent, are on shaky legal ground. Scholars noted the parallels: regulators using their power to pressure companies into silencing critics. The fact that Nexstar, needing FCC approval, acted first was seen as a smoking gun. Even administration-friendly experts expressed concern, citing the unanimous Supreme Court ruling. Any legal challenge against the FCC would likely succeed. The government's case is weak. The Supreme Court's decision was designed to prevent exactly this scenario. Broadcasters now have strong First Amendment protection against government pressure. The Supreme Court's ruling and the FCC controversy have dramatically altered the landscape for media, politics, and law in America. What was once a familiar terrain has now shifted, leaving institutions and individuals alike to grapple with new realities and uncertainties. The ripple effects of these decisions are being felt far beyond the courtroom, reaching into newsrooms, boardrooms, and the very heart of public discourse. Civil liberties groups and media organizations are mobilizing rapidly, preparing a wave of legal challenges. They're drawing on the Vulo decision as their primary weapon, hoping to set new precedents that will protect freedom of expression for years to come. Meetings are happening behind closed doors. Strategies are being drafted, and alliances are forming across ideological lines. Meanwhile, the administration faces a pivotal decision: should it double down on its approach, risking further legal battles, or step back in the face of a unified Supreme Court precedent? The stakes are high, and every move is being watched closely by both supporters and critics. For the media, the threat of government pressure is still very real. Yet, the Vullo ruling now offers a powerful legal shield, giving journalists and news organizations renewed confidence to pursue stories that matter, even when they challenge those in power. This moment could galvanize the industry, inspiring journalists and media executives to assert their First Amendment rights more forcefully than ever before. There's a sense of unity and determination as the industry recognizes the importance of standing together in defense of press freedom. The path forward will depend on whether the courts continue to uphold Vullo's principles and whether media companies have the courage to resist external pressures. Legal battles are likely to continue, and the outcomes will shape the boundaries of free speech for a generation. The answers aren't clear yet. The road ahead is uncertain, filled with both risks and opportunities for those willing to defend constitutional rights. We're entering a new chapter in American history, one where the meaning of free speech will be tested and redefined in courtrooms, boardrooms, and government halls across the nation. In this evolving landscape, vigilance is required from us all. The future of free expression depends on our collective awareness, engagement, and willingness to stand up for the principles that define our democracy. This story is about more than the NRA or a late-night show. It's about the character of our country. The principle that government can't silence voices it dislikes is a pillar of a free society. It protects everyone, regardless of political views. Free speech and a free press are responsibilities we all share. When these freedoms are threatened, it's a problem for everyone. The Supreme Court drew a clear line, but it's up to us to uphold it. Legal groups, media companies, and the public must all defend these rights. Stay informed, pay attention to government actions, and speak out. The future of free expression is decided by our daily choices. This is our shared journey. Let's protect it together.